The government wouldn't fund this research. The NIH wouldn't fund this research if they thought it posed a grave risk, not just to these plaintiffs, but to everyone.
The government is never wrong.
I'm not here to say that, Your Honor.
Let me say that today.
Golden versus EcoHealth Alliance. You may proceed.
Good afternoon. May it please the court. I am Patricia Finn. Can you hear me now?
Better.
I am Patricia Finn. I'm here today on behalf of the appellants in the matter of Golden versus EcoHealth. We're appealing two orders of the trial court. One, granting a respondent's motion to dismiss, and the other, a denial of a CPLR 2221 renewal motion.
Why don't we focus on the first one, since
Yes,
the
ma'am.
latter,
Okay.
right? Go ahead.
Indeed, you think so. So I think the important issue here, there's two key factors. First, respondent appears to have recasted this case as nothing more than an issue of funding scientific research.
Well, what evidence do you supply to show that it's anything other than funding, other than a bunch of conclusory statements in your complaint, which say they collect, they transmit, they this, they that, but you couch this defendant along with every other actor who's not in this country, right? So explain to me where in your complaint specifically there are actual facts, not conclusions, not conjecture.
I understand
Right?
your question, and I respectfully disagree.
That's nice. Tell me where in your
I'm
complaint.
about to, Your Honor. Okay, their own evidence, their own contract.
Counsel, my question
In
is,
the complaint.
where in the complaint do I have facts to support it?
Your Honor, the facts are in the complaint to establish.
Tell me where they are.
I don't have the complaint with me. I'm here.
I'm sorry. You came here to argue a very important case.
I'll get the complaint. The complaint's back there. Your Honor, there were 7 counts. Each of the counts included evidence. We also provided.
What evidence?
I'm getting to that. We've also provided a copy of the Inspector Grimm,
The Grimm report.
the Grimm report, which clearly said, well, first of all, there was no burden on me to provide evidence.
A complaint has to at least have a bare modicum of facts to support it, not just conclusions.
Okay, so,
So I've asked you about 4 times now, what are the facts? Because again, I can go to the complaint. I printed it,
okay.
right? And the only, let's go to the strict liability claim, because I think it's the only one that has any potential oxygen, right? You talk about those working in furtherance of this enterprise, but there's no facts to support that. Outside of, we gave the Wuhan lab funding sources.
Your Honor, that's completely inaccurate. The plaintiffs themselves, EcoHealth and Peter Daszak, were named in this complaint, and they were the individuals involved in Wuhan. They were involved in the collection and sampling of bat viruses, the manipulation of those bat viruses.
So I get, again, what facts are you pleading to support that? So you're saying on December 31st, this individual defendant was in China collecting and mutating viruses. Is that your allegation?
Excuse me, Your Honor. It was far more than that. It was over a period beginning in 2000.
Okay, so I'm asking you, where is that allegation?
It's in the complaint. They are in the complaint. We allege these two defendants were absolutely involved in the collection.
Yes, and you allege it in the most amorphous an unfactually based way. And that's, I think, what we're all trying to struggle with. You have to have a good faith basis, factual basis, to come to a conclusion that someone actually did this. If you are saying this doctor was in the Wuhan lab from this date to this date, is that in the complaint?
Yes, it is.
Where? Show me.
I don't have the complaint.
Well, okay, so we've all read the complaint and we didn't see it, so
Your Honor,
unless you can point it out, we're going to have a problem.
Obviously, I see that, and I regret that deeply. But the Inspector Grimm report, which was the evidence we provided, clearly set out that EcoHealth and Defendant Peter Daszak were involved in the creation and distribution and release of the COVID-19 virus.
All right, you'll have time on rebuttal. You may proceed.
Good afternoon, Your Honors, and if it may please the court, I'm Juan Olivo, and I'm here on behalf of the respondents. I want to touch on what Your Honor just brought up with respect to strict liability, because it's the only claim that may have oxygen to it. The court's aware of the factors in Dudakis versus Hempstead, which outlined the analysis for whether or not there is strict liability. And what I want to jump into is, in her complaint, the plaintiffs allege throughout that EcoHealth Alliance and Dr. Daszak negligently carried out this conspiracy, if you will, just borrowing words from the complaint. At the same time, they're trying to ask the court to sustain a strict liability claim. So in one hand, they're saying EcoHealth Alliance and Dr. Daszak acted negligently, but at the same time, they're telling you there's a claim that's viable that shouldn't be struck down, because it doesn't matter how much care they would have exercised. It doesn't matter if they were negligent.
So let me ask you, was Dr. Daszak in Wuhan?
Your Honor, I can't answer the question of whether or not Dr. Daszak was in Wuhan on December 31st, 2019, but he's been to China before.
Okay.
But the allegation that
question,
he's...
right, that
the
he is
allegation
the
that
one.
he's
Counsel, my colleague is talking,
Sorry.
and when the court is talking, you shouldn't be.
I'm just trying to figure out if the allegation is that he actually did the virus manipulation.
Your Honor, I think that's what the allegation is.
Okay, because I didn't see it in the complaint.
Right. I think, neither did I. It's very difficult to understand what the actual allegations were. And as a matter of fact, my adversary said that we casted the allegations of the complaint as one of regarding funding. That was actually Judge Rashan in the Southern District of New York in a case called EcoHealth versus EcoHealth Alliance, who picked up on the fact that this is the best you could take the allegations of the complaint and the best cause of action that you could set forth is a funding cause of action.
All right, well, let's take it as a funding. Is the manipulation of viruses in a foreign country over which the United States would have little to no control over, with the purpose of trying to create stronger strains of virus, an abnormally dangerous activity?
I would say the answer to that question is no, Your Honor. But that's not necessarily the question.
Why? Why is it not?
In this regard, it's because the government authorized this research to take place. The government issued a grant.
So it's okay to do abnormally dangerous things so long as the government says it's okay?
Well, I wouldn't say that, Your Honor. What I will say is there would need to be something to be
Be
resolved.
very careful how you answer, okay?
Right.
Because like you, we're lawyers too, right? So we're listening to every word you say, okay? And so if this was too dangerous, it's not abnormally dangerous because the government funded it, then you're saying that all case law should say that if government funds research, that ends the inquiry?
No, Your Honor, and thank you for stopping me from that. Let me clarify. That does not end the inquiry. What I should say is that the government wouldn't fund this research. The NIH wouldn't fund this research if they thought it posed a grave risk, not just to these plaintiffs, but to
The
everyone.
government is never wrong.
I'm not here to say that, Your Honor.
Let me
Say that today. Okay.
They did decide in April 2020 to discontinue the funding,
I should say, Your Honor,
or cease the funding, suspend the funding, whatever the appropriate
the
word is.
proposal at issue, Your Honor, ended in September of 2019. It was a 5-year research grant that commenced in 2014. It ended in 2019.
I saw that statement, but where in the record is there proof that it ended in 2019? Could you tell me where in the record I could find that documentary evidence that tells me, that puts the nail in that particular date, that that's the date it ended?
I cannot, Your Honor.
Okay, because I couldn't either.
Yeah.
So that's a problem, because you make this assertion, but I see nothing in the record to support that statement.
What I will say, Your Honor, this is
May
what
I
you were-
ask you a different question? Are you arguing, for example, that research into viruses so that we can create vaccines shouldn't be considered a normally dangerous activity, right?
No, Your Honor, that's not exactly what I'm arguing.
What are you arguing then? It should be considered abnormally dangerous? Should we not
That
be
was a
doing it?
softball
I
question,
know,
by the way.
I was trying to help you out there, and it didn't go very far.
I'll answer the question. What I'm arguing, Your Honor, is if the NIH issues an award to a nonprofit research institution to conduct research that provides for subcontracting the research outside of the country, that should not be subject to strict liability.
Okay.
Is that because there are gain-of-function research, while it may entail some dangers, also has significant societal benefits?
That is correct, Your Honor.
Okay, thank you.
So, if I may, I'd like to answer the questions as quickly as I can. There is no time in the history of the gain-of-function research, such as December 2019, where we alleged the activity occurred. It was over a period of years, beginning in December through the release of the virus. Secondly, Your Honor, with respect to gain of function, the prime contractors, prime contracts that were awarded to EcoHealth all specifically contained provisions that they were responsible for their subcontractor research. Third, Your Honor, Congress has already determined that the type of gain-of-function research that went on at Wuhan, which as prime contractors, EcoHealth was 100% responsible.
Is this the report that happened after this case was decided?
No, it's the statute that was cited in our briefs that if you...
Was it done after the case was decided, is my question. There was a report here that...
Yes, but you've already determined not to provide judicial notice to that. I'm not talking about that.
Okay.
I'm very careful about that.
Okay, I was just making sure. Good.
No, but prior to that, their contracts, their prime contracts, any prime contractor, any federal prime contractor is responsible 100% for the activities of their subcontractors, whether they're in the United States or they're in China. And finally, the point I'd like to make, distinguishing between strict liability and negligence. I want to be very clear. Congress has already indicated that the type of activity that went on in Wuhan, manipulating viruses, is strict liability. It completely fits under the factors of Dundalakis that my adversary here mentioned, okay? Well, our position is we fit 100% under Dundalakis and Spano. With respect to negligence...
You're out of time. I'm going to give you another 30 seconds, and then that's it.
And that's all I need.
All right.
With respect to the negligence was a separate cause of action that involved the release of the virus and the cover-up of the virus. And I respectfully submit...
And you're claiming that's EcoHealth?
It was EcoHealth, and they covered it up. They engaged in a conspiracy.
EcoHealth was in charge of all of the records that were under the control of the Wuhan lab and the Chinese government. That's your argument.
Not at all. EcoHealth was responsible for the records.
I heard that argument already, but I'm talking about post-outbreak when we all know that we were getting no information from the Chinese government. So If our government couldn't get information from the Chinese government, we expected that EcoHealth could? That's your argument?
EcoHealth was the one generating the record.
All right, thank you.
Thank you very much. I appreciate your time.